Dear viewers, this is Shobhitra Lahiri, author of Guide to IBC.com. While saying that I'm author to Guide to IBC.com, I sometimes wonder whether I should call myself an author, really an author or not. Because in Guide to IBC, apart from the introduction part, maybe while about the author or some tidbits, nothing is written by me. Guide to IBC comprises of excerpts from various court judgments. It speaks of the wisdom of the magnificent judges we have in NCLAT, Supreme Court, and the High Courts and various other courts. And what I have done is, I have extracted relevant portions of the judgments, segregated them section-wise, regulation-wise, and created the topics. And topics are essentially headlines of the judgments only. So, being an insolvency professional, I think rather than author, I should call myself a collator. But this debate we can continue later. This week there has not been too many judgments, but there are some important judgments which we will talk about. But does it mean that other judgments are not important? All judgments are important. So what we are doing is we are taking some exceptional cases and telling you. But all cases are important. Please see the homepage. Whatever new cases are recorded there, uploaded in website, they are all featuring, they look at the topics, and so that you are aware of the trend of the progression of insolvency bankruptcy code. So with this, we switch over to the next part of the video.
And see guide to IBC.com on your screen. Let us first select a case of section 3. Now, this is the case of Messrs. Starmax Properties versus Orurapu Shigta. Company appeal at Insolvency 338 of 2024. The judgment came very recently. The topic is any direction in the arbitral award restraining the corporate debtor shall not create any charge or security interest. Yes. Basically, the case comprises of case basically deals in a topic. There was an agreement between a buyer and the builder. As per the agreement, buyer had the sole discretion to sole option or sole discretion to exercise the option to cancel the book. And there was an articles of agreement between the buyer and the developer. There was no such builder-buyer agreement. And they had gone to arbitration. And in the arbitrator ordered that no security interest should be claimed. Now this company went into insolvency. The RP, when they filed the claim, RP declined. The RP showed it as a secure creditor, but showed it as security interest to be nil. So the matter went to NCLAT. NCLAT was of the view that the award given by arbitral award clause 5 direction was issued by an arbitrator that corporate debtor is restrained from allotting or alienating or dealing with or disposing of or creating any sort of third party right or interest in the secured disputed properties. Arbitrator had not examined the question as to whether articles of agreement, which was the basis of arbitration proceeding, creates any security interest within the ambit of IBC. So, NCLAT said that this arbitration direction does not create any security interest, especially because this person cannot be treated as home buyer. Had he been a home buyer, because if had he been a home buyer, there would have been buyer-builder-buyer agreement. Herein, there was an articles of agreement which was not a builder buyer act. Now, let us go to there are some there is there are some judgments which I feel is very important and which I'm going to discuss with you. And let us go to Regulation 31. Regulation 31, I did not say it, but it says that uh, Regulation 31 pertains to insolvency resolution process. Now, this is a Supreme Court case, very recent case. Aditya Khaitan versus State of Jharkhand and others. Criminal appeal number 2000, I mean, of 2025, SLP criminal number 15413 of 2020. Amount due to a person whose rights are prejudicially affected on on account of moratorium does not necessarily implicate criminal impacts. What happened was there was a contract between Nali Bharat, which is in insolvency, and with NBCC. Yes, NBCC. McNally Bharat had appointed a third party, a subcontract, without noticing that the subcontractor, I mean, they needed to take permission of NBCCL to have a subcontract. As a result, when the subcontractor filed a suit, our moratorium was imposed on McNally Bharat, and accordingly, there was some delay in payment. And the contractor filed claim, but at the same time, he instituted criminal suit for suppression of fact that they were not entitled to appoint a subcontractor without informing NBCCL. Now, Supreme Court went into it and said that, okay, yes, your right is affected. Now, NBCCL cannot take any action against the complainant since it has no privity of contract with the complaint. Now, the complainant was the subcontractor. His relationship is with McNally Bharat. As far as NBCCL, there is no nothing. And subsequently, the work started. The same billing and everything started. Now, what is 31? What does 31B say? If any party's right is prejudicially affected with the with moratorium being effective, with moratorium being there, in such case, under section 14(1)D, of course, 14(1)D may not apply here. But his right is definitely, to some extent, prejudicially affected due to imposition of moratorium. Then payment may have been affected, but this is very much after all. Thereafter, the payment started, and everything is normal. But there was no criminal impact. Supreme Court made it very clear that there was no criminality arising from the allegations. Prima facie, allegations do not constitute any offense or make out any case against accused persons. Now, I have faced situations, frankly speaking, as insolvency professionals, I have faced situations wherein IBC is essentially a civil forum, and operational creditors often resort to criminal proceeding, and we are at a loss to know how to go out of it. I mean, it's usually done against the corporate debtor. So this case is important because this bridges between there is a connection between criminal court, criminal applicability, and insolvency process. So a creditor need not, because his payment is getting due, he cannot come and say that, okay, let me institute criminal proceedings. No, that is not. Now, let us go to liquidation. Now, let us come to regulation. Regulation 10 pertains to disclaimer of onerous. Onerous property includes onerous contracts also. Now, there has not been far too many cases with respect to onerous property or onerous contract. In my website, in the not I should not say my website, in Guide to IBC, I have most of the cases and most of the topics are created out of old judgments of Supreme Court and the various high courts pertaining to onerous. In insolvency bankruptcy court, onerous property cases are very few. And this case is a very recent case in which this is topic number 3. Yeah. Any contract which is found to be unprofitable and onerous, even if undertaken to some extent by the liquidator, can be disclaimed by the liquidator with the leave of. Now, there was a judgment earlier of official liquidator versus Dhaka Chemical and Products Limited, 15 September 67 Madras High Court. Now, you have the judgment of 2025 last week or this week itself. Tarla Performance Farmers Limited versus Mr. Vivek Muralidhar Nabhade Company, appeal number 371 to 381 of 2025. So, in which the court says that, and court also considers the fact that whether Regulation 10 is ultra vires liquidation regulations or not. So, court has said that Regulation 10, liquidation regulation, is very fully covered by Section 35(1) subclause O. So, this is very much, coming within the ambit of liquidation regulations. Any contract which is onerous, which is unprofitable, the liquidator can zone it with the leave of. And it has also stated that as per Section 34(2) on the appointment of liquidator under section, all powers of the board of directors and key managerial persons and the partners of the corporate debtor, as the case may be, shall cease to have effect and shall be vested in the liquidator. Section 35(1)(o) empowers the liquidator to perform such other functions as may be specified. So if a board can disown a contract, so the liquidator can. So this is an important case which I think you should go through it. This is quite important, especially since it deals with onerous property and we don't have too many onerous contracts. So we can definitely look in. Let us go to 67, that is, now why I'm saying this is for a very particular purpose. You will remember that I had in one of my podcasts had mentioned about Piramal Capital judgment, which stated that the adjudicating authority is empowered to pass orders to avoid or set aside avoidance transactions. But in fraudulent or wrongful trading, the adjudicating authority is not empowered to pass orders to avoid or set aside such transactions. They can impose costs. They can ask the CD or the errant person to pay to the liquidation estate, but they cannot set aside. In Piramal Capital Housing Finance Limited versus 63 Moons, I had shown you. This case is very recent, of this with Sangeeta Jatinder Mehta and another versus Kailasha RP, Section 104, Company Appeal 104 of 2024. Though in this particular judgment, NCLAT has not, Honorable NCLAT has not referred to Piramal judgment. But it has said that there is There is no error in the judgment of adjudicating authority insofar as it held that the transaction of payment of consultancy charges for appellant number 1 or 2 were not bona fide transactions. Since the appellants are still discharging the liabilities of the loans, Honorable Enclave was of the view the sale transaction in favor of the appellant could not have been declared void. Actually, it could not have been declared void because Section 66 does not empower adjudicating authority to declare or set aside a transaction. So, which has not been, but in effect, it says the same thing. Now we will rather shift. There have been some important judgments, Supreme Court judgments and implied judgments pertaining to personal capitals. So let us shift our attention to those cases. So first, we come to Section 95, topic 30. Any admission of liability by the borrower shall be deemed to be admission of debt by the guarantor as well. The balance sheet being a part of the record of the tribunal must be looked into for the purpose of extension of limitation for extension of limitation from the date of acknowledgement. We know about Bank of Baroda case. So in this particular debate, Sher Singh Agarwal versus State Bank of India and others, Company Appeal 17902024 and it held that the same thing, the admission of liability of the borrower will be deemed to be admission of debt of the current as well. And the balance sheet being kept the record of the tribunal has to be looked into for the purpose of extension of limitation from the date of acknowledgement under Section 18 of Limitation Act. So the notice of invoking guarantee deed was 16 January 2017 in relation to guarantee date dated 17th December 2014. Was in hand delivered to the appellant. Default occurred on 31st January 2017, and in between, while the period of limitation was continuing, the corporate debtor acknowledged the debt in balance sheets, which further enlarged the period of limitation from every date of such an acknowledgement. So this is important. We can face such situations since now personal insolvency is very much in vogue. So this kind of situation can very much arise. There is another, this case is also important in Section 94. An interesting case. Section 94 petition cannot be entertained when the proceedings were not initiated with the intent of genuine insolvency resolution. Section 94 is what? When a personal guarantor or, in initial insolvency, when the person itself institutes the borrower or institutes the insolvency proceeding, not the financial institution. So in this particular case, cites Siraji Saliki and Qadri versus Edelweiss Company Appeal 455 of 2025. What happened is that a person had borrowed money from Edelweiss and could make the financial creditor issued various cases in DRT, surfacing, DRT in High Court, and this and that. And whenever it came to grabbing the property, it went to one fora to the other. It somehow could make them go round and round for 13 long years. And ultimately, when all doors were closing, they instituted corporate. They moved to Section 90. The court held that the intention of the party for instituting 94 was to take undue advantage of interim moratorium under Section 96. And when the intention is not genuine insolvency, but otherwise, I mean, you cannot use insolvency as a protection for mischievous intent. So 94 was not entertained. Even this is there in 96 also. We have given a topic in 96 as well. Moratorium under Section 96 cannot be utilized mischievous. And this is the same case. Syed Sijali Saikin Khadri versus Edelweiss. So this is no doubt important. Um, could be the, whenever people get stuck, they think of using 94 as a protection, but then it's not that. Now, let us come to a very recent case which I saw today is in Section 96 only. Now, we will remember that I had referred to, in one of my podcasts, I had referred to a Supreme Court judgment and said that with regard to when a personal insolvency is instituted, when a Section 138 petition comes, 138 in Supreme Court itself, in one of the judgments which I don't remember right now, that said that it relates to that debt. But today we have a judgment, a very specific judgment of Supreme Court, which says that the moratorium under Section 101, which reprises Section 96, will not bar the continuation of any criminal action. Thus, prosecution under Section 138 of NI Act may continue. Rakesh Bhanot versus Mrs. Gurdas Agro Private Limited Criminal Appeal. There are multiple appeals and there are multiple appeal petitions were taken up in the Supreme Court. And Supreme Court it said that the moratorium under Section 96 is intended to offer protection only against civil claim to recover debt. There is no protection to any individual who is prosecuted for committing a criminal act. The interim moratorium, which commences on the presentation of application, will expire on admission of the application by an order of adjudicating under Section 2. On admission of moratorium section, on admission of 100, the moratorium under Section 101 will come into operation. Moratorium under Section 96 and 101 are not indeed intended to shield individuals from personal criminal liabilities arising from their actions outside the scope of corporate restructuring. The respective appellants having filed insolvency applications as personal guarantors under Section 94 IBC cannot extend this protection to avoid prosecution under Section 138 of NI Act 1881. The distinction between the right to sue based on a dishonored check by initiating a civil suit and launching a prosecution under Section 138 of negotiable instrument are significant. In the case of former, the interim moratorium can operate. But in the case of later, but not in the case of later. That means the right to sue is a civil matter which can come under the moratorium under Section 96 or 101. Right to sue. But once a suit is instituted, under Section 138, then in such case it becomes a criminal. It becomes a criminal, and it is moratorium under Section 96 or 101 does not. So thus, whatever hope we had, or whatever we shouldn't say this is absolutely a new thing which has come into being, and there are many personal guarantors who are facing 138 petitions, 138 prosecutions. So beware, this does not absolve you from your responsibility. So with this, we come to the concluding part of the presentation.
Viewers, we have come to the end of our presentation. We have May Day tomorrow, so it's going to be a holiday. And tomorrow and the weekend will follow soon. So I wish you all a very happy and peaceful weekend. I hope you have enjoyed the presentation. The next week we'll again have cases and I'll come back to you. And so till then, bye for now.